That process took about a year to obtain the permit. There was a claim that we breached this compromise agreement, but by not obtaining that permit more promptly than it was obtained. There was a claim that the town employed the services of the law firm of Wallace, Smith & Palmer in violation of the terms of the compromise agreement, which prohibited Wallace, Smith & Palmer from acting upon any matters in which New England National was involved. I think there were one or two other. There was a recording of a Mylar relating to a lot line revision that was supposed to have been filed and wasn't filed, and there were issues as to whether that Mylar actually existed, whether it was filed, whether it wasn't filed. And there was a claim of breach of the compromise agreement relative to the settlement of the litigation with AIG, which New England National alleged that the town went and settled without New England National's approval and participation. There may have been one or two other issues, but those, I think, are the major issues.
Thank you, Mr. Brown. Yes, sir.
Hi, John Cesario, 15 Darrows Ridge. I have a question as far as the easements, in terms of trying to recoup some of this money. And, you know, and most of you know that I've been the biggest hollerer at Mr. Formica and Mr. Block and Sicily, how they've handled this case. But there's a possibility of recouping some of the money. So the questions is this: does the acquisition of the pond property and the release of the title encumbering the easements allow the town to purchase grants from the state for deep open space land acquisition, the grant program?
Mr. Sawyer, you have a number of questions?
Yeah, I have a number.
You want to answer them one at a time?
Yeah, because
Okay.
they're complicated, and it might give the public some information that the town may be able to recoup
Okay.
some of
Let's
this.
try to get an answer for the first question. Is there anyone who could answer that question?
I believe it's probably in Mr. Formica's realm rather than my realm concerning open space grants and the availability of those grants.
The answer is we don't know, but we're going to try to pursue that. And speaking with Board of Finance Chairman Harney, who may want to address this issue, and has been a proponent of open space and kind of made himself somewhat of an expert over the last few years in open space, has mentioned to me that there's a potential of us getting some grant dollars. And I'm sure that the new First Selectman and the Board of Selectmen will proceed with that as expeditiously as possible once the settlement is reached. Shall I stay here, Mr. Cesare?
Yeah, you probably might want to stick around. Did the town obtain title insurance when it bought the Darrow Pond property? And if so, were all of these easements that we're paying to be released exceptions to the title insurance policy?
You want-
The town did obtain an owner's title insurance policy at the time it purchased the Darrow's Pond property. As far as I'm aware, the easements that are included in this settlement and were included in the Darrow's Pond property were exceptions to title. So I know of no errors in the title policy that was provided to the town.
Have you looked at the title insurance policy?
Yes.
If the easements being released were not exceptions, will the town pursue a claim or request for a contribution from the title insurance company if, in fact, what you just stated is untrue? Not that you did the title, but if you just made a mistake.
If there is any error in the title insurance policy, and if that error has caused a monetary loss to the town of East Lyme, then it would be incumbent upon the town and its council to file a title claim, if that in fact is true.
Okay, last question for now, and then I'll let other people speak. So there is a possibility of recouping some of this money. If this settlement's not approved tonight, You had mentioned the cost might be substantial. What would you estimate the legal cost if this goes to trial? And how much is the lawsuit against the town for if the town loses and doesn't settle tonight?
We have estimated and provided the town with an estimate that if the litigation were to continue, it would probably cost the town $200,000 to $300,000 in legal fees and expenses. As far as the damages that are claimed, we've had various numbers that have been thrown out over the years. The claims may be as much as $9 or $10 million. They may be as little as $4 or $5 million. We have not gotten a specific itemized damage claim from New England National. This is part of the litigation process which we would have pursued. But over time, there have been various damage claims that have been asserted, although we do not have the evidence of all of those claims or the proofs of the evidence of all of those claims. But we would be defending a suit that would be at least claimed to be several millions of dollars.
Thank you, Mr. Brown. Would anyone else like to be heard? Mr. Sarah, are you done with your questions?
Yeah, I do have, as a follow-up, it was stated that the town is going to be a minus 1.2 million after this settlement. I did some Freedom of Information requests, and Attorney Block's firm is paid nearly upward of $400,000. O'Connell's firm nearly $200,000, and $150,000 to Tobin, plus $1 million. You recouped $175,000. So I think the figure that's been expended at the taxpayers, correct me if I'm wrong, is more like $1.6 million. When you mentioned $1.2 million, did you account for all the attorney's fees?
I mentioned a rough estimate, which I thought would be about 600 or 650,000, which would include the 250 in the compromise agreement and about 300 or 400,000 in attorney's fees at that time, and added the 650. That's how I came up with it. Anna, do we have the number for the first 600? Was I right? Were we in the 600 range? 650 plus 650, so $1,300,000. You said $1 million, and I'm not sure where you got that number.
Well, if we're giving New England National $650 and we've already given them $350, that's $1 million, plus $650 in attorney's fees.
No, the 650 included the money we gave New England National.
We're giving them $650 tonight. You've already given them $350.
Not counting the insurance money, the $100,000, I don't know that I included that or not, because that came from the insurance company. So we're in the ballpark of $100,000. It could be $1,300,000, it could be $1,400,000, but I think it's more in the $1,250,000 to $1,300,000. That's my guess, but Anna is shaking her head yes at this point. She's the finance director.
That's the
Okay.
It's $200,000, but I have the legal fees. So.
All right. We're not going to carry a conversation between the two. Mr. Mingo, you wanted to be recognized?
Can I sit here or no, I have to get up?
No, you have to come up because it's being televised.
I have some prepared questions that I want to do later on, but relative to the questions and it's germane to what is happening right now. I have a little bit of knowledge on corporate law, and I am nowhere near an attorney, but there's a reason why the word LLC is used in corporations, because it limits the liability. What's to prevent the principals of New England National to organize under another corporation and come back into town and do business?
Mr. Block, you want to answer that?
The
Ms.
answer
Mingo,
to
stay
that-
there. If you're going to have some more questions, just wait right there.
I have no more questions on this issue.
The answer is that the agreement specifically prohibits New England National or any of its members or affiliates from doing business with any other entity or as part of any other entity. So it covers their current business and any future business relationships they may have, so they cannot come back in the guise of another entity and engage in business.
Thank you, Mr. Block. Would anyone else like to be recognized? Mr. Drabeck?
John Dravick, 18 Dravick Road. Well, the insurance company coughed up a little bit for the first settlement, which was the settlement to end all settlements. But I've yet to hear the word insurance company on this portion of the settlement. I want to know why, way back in about 6 years ago in this room, when we voted for the first money, I was the only person in the whole stinking room who voted no. Why did we indemnify the insurance company, which we pay to take care of this court litigation? We pay this group to do it, and you absolve them of any responsibility here, put it on the backs of the taxpayer. I have yet to hear anybody say what we did wrong, where we have to give a settlement. Did we really screw up? Did the town really screw up that bad? Did they really inhibit this New England National from developing their property? Nobody has admitted any guilt here. Doesn't seem to make it to court. It gets bounced around, and everybody, all they can talk about is settlement, settlement, settlement. Well, I'm tired of settling every time somebody in town screws up, and I think that's what happened. The town was guilty. So you're trying to limit the damages to me by taking more money from the taxpayer, saying, well, I might save you $1 million, $13 million, $5 million. Nobody knows for sure, except I already paid for litigation and litigation. I get tired of being tapped because somebody screwed up, and nobody wants to say who. I think at this point the taxpayer is owed it. I have another problem with having a town meeting without having a public hearing 2 or 3 weeks before. You come down, you jam it down our throats in the last couple of minutes like you did the last settlement. Nobody has a chance to really prepare, except, oh, the court said this, the court said that. So where is the town's insurance company on this, and how much are they contributing? Or did you indemnify them in this action also? That's the question.
Attorney Sisley, you want to answer that question?
Yes, Amanda Sisley, also special counsel for the town of East Lyme on this matter. Some people have raised the question regarding the insurance company and insurance coverage in the past, and inquired as to why the town no longer has any insurance for the claims made by New England National. While this is a very complicated issue, I will do my best to provide an abbreviated explanation. As Mr. Formica had indicated earlier, this action had started a long time ago, and the town had assessed New England National real estate taxes, which New England National refused to pay. When the town of East Lyme filed a proof of claim seeking payment of these taxes in the bankruptcy court, New England National filed an objection to the payment in which it made vague assertions regarding alleged improper conduct of certain former town employees and agents. At that time, New England National never filed a formal lawsuit against the town nor any of the town's employees or agents. Over the next few years, New England National sought to pursue those claims through their objection rather than by formal adversary complaint or lawsuit. When Paul Formica took office several years later, he first sought insurance coverage for these claims. The town had hoped to obtain insurance coverage for the claims, but was not sure that it could obtain coverage because, one, the town did not notify the insurance carrier earlier on when the claims first surfaced, and again, this was due to the peculiar nature in which these claims were first raised. New England National's claims were also related to conduct of certain town's employees, and they claimed that the town's employees acted outside the scope of their employment to intentionally harm them. If that's the case, the town would not be required to indemnify these employees, and therefore the insurance company would not pay for any defense or any judgment against them. Shortly thereafter, the town entered into the 2008 compromise agreement with New England National and its affiliates. The compromise agreement required the town to pay New England National $250,000 upon the signing, which it did back in December 2008, and the first $100,000 from any insurance settlement or proceeds received from AIG as a result of a resolution with them or a declaratory judgment action. It was understood at that time that the compromise agreement was a full and final settlement with the town of East Lyme, but New England National was reserving its right to assert claims against third parties, which included certain former town employees. Given the uncertainty of the outcome of any such lawsuit that New England National may have filed, the compromise agreement limited the town's exposure in the event that that occurred. Specifically, to the extent that NEN actually pursued the claims against those third parties, and if one or more of those third parties sought to be indemnified by the town of East Lyme, and if the town was obligated to pay any judgment rendered against the third parties, the town would only be obligated to pay such judgment if there was insurance coverage for the same. However, New England National never filed any complaint against any of these former town employees. Ultimately, the town's insurance carrier denied coverage, and the town was forced to file a lawsuit against the carrier to obtain coverage. The insurance carrier asserted over 20 defenses to the claims the town made. The town met with the insurance carrier's attorneys and New England National and tried to reach a global resolution of the matter. AIG's position was that the sum total of the insurance claim was limited to $350,000. The $250,000 that the town had already paid, plus the $100,000 it was obligated to pay out of any insurance proceeds. New England National claimed that the claim was much greater because the claims against the former town employees that New England National retained were still out there. However, again, New England National never sued those employees or filed any formal complaint pleading seeking to pursue these claims, and at this point, the applicable statute of limitations would have now passed, which would bar New England National from pursuing those retained claims. New England National's differing opinion on this issue prevented the town from being able to reach a global settlement at that time with New England National and AIG. Also, New England National had not provided the town and AIG with sufficient evidence of the losses it claimed to have suffered as a result of the alleged improper conduct of the former town employees. Also during this time, New England National commenced an action against the town of East Lyme, claiming that the town breached the compromise agreement. The breach of compromise agreement claims would not have ever been covered by any insurance policy the town had by virtue of the normal exclusions in such policy. So the town was spending significant funds of money to defend the breach of compromise action, and also was forced to spend the money to pursue the declaratory judgment action against AIG. Based upon the lawsuits and the relationship between the town and New England National had further deteriorated, and the town was having difficulty obtaining the information that it needed from NEN to pursue the lawsuit against the insurance carrier. Under the compromise agreement, NEN was obligated to cooperate with the town in the pursuit of the lawsuit against the insurance carrier, which the town claims that NEN failed to do so. And this is part of the claims that the town had made in the current lawsuit against New England National. In light of the defenses that were raised by AIG, at least some of which the town believed had some merit, the town was very concerned that coverage would ultimately be denied, and the town would have spent significant legal fees to pursue AIG and recover nothing. The town was also not convinced that prosecuting the action against the insurance carrier to judgment would prevent NEN from pursuing the town, especially given the fact that NEN had already filed the action for breach of compromise, and the town was defending that case as well as additional claims NEN was threatening to add. Ultimately, through mediation, AIG and the town reached a settlement. The settlement required the town to pay AIG to pay the town $275,000. The first $100,000 was paid to NEN pursuant to the compromise agreement. Given the defenses raised by the insurance carrier, NEN's failure to take any action to pursue the retained claims against the former town employees, and the pending lawsuit, the Board of Selectmen and Board of Finance decided that this settlement was in the best interest of the town. Given NEN's litigious nature, AIG was concerned that that New England National would seek to sue them directly. Accordingly, AIG conditioned the settlement on the town agreeing to pay for the cost of any defense and any judgment if New England National were to sue AIG for the retained claims. Given that NEN had not yet pursued these claims and the statute of limitations had run, the town agreed to this provision, which it believed posed a minimal risk to the town. The town is not now and has never been self-insured. It has all times maintained sufficient general liability coverage. The settlement with AIG simply limited AIG's exposure under the insurance policies issued to the town of East Lyme from July 2005 to July 2008. The town's settlement with AIG was a business decision made by the town, which was then believed to be in the best interest of the town given all the circumstances that have been described. The town would still have coverage for any claims that may have subsequently arisen, subject to, of course, to the ordinary limitations of coverage and exclusions in the town's policies.
Thank you, Attorney Sicily. Mr. Dravic, you still have the
Boy,
floor.
she lost me about the fourth page back. Was that complicated or what? It was. You folks might be able to make the decision, but you've had a few weeks to think about it, yet you're stuffing this to the taxpayer at a town meeting in the course of a couple hours, not even. I'd like this to go to a referendum vote, and I think there's two boards should ask this to go to a referendum vote. I'd also like to pass 6 pages of what this young lady just read posted somewhere so we can all have a copy to make a better decision. I have people, it looks like people let statutes or limitations go by so liabilities wouldn't be carried. That doesn't sound right. We basing all this on 2 town employees who apparently did something wrong, nobody knows what. I think you're trying to buffalo somebody here, thinking it's just going away just to save us a few bucks. Tell you what, I don't care. If town employees screwed up, town employees screwed up. They should be held accountable. If elected officials knew this was going on, then they should be called on the carpet for it. I don't like kicking the can down the road and ending up with lousy decision makers up in the office here. Now, Mr. Nickerson's going to be our next first selectman in a day or so. That's the rumor. I'd like him to maybe to answer some of the next questions coming up because he's going to have to carry the next load. I think our boards of selectmen have been kicking this down the road since 2003. As a taxpayer, I don't like it. I don't want to have to pay it, but I'd be damned if I'm going to come to a town meeting, listen to that dissertation. I'm not saying she's wrong. That's probably the most correct thing we've heard for the past 3 years or 13 years to come up with a better decision. I want this to go to referendum vote. I want it at least 2 weeks from now so we can decipher this mess that you've gotten us into. And I say, yeah, you've gotten us into it. Thank you.
Thank you, Mr. Dravic. Would anyone else like to be heard? Okay, Mr. Cesaro?
Again, John Cesario, there's an expression, you know someone's lying when their lips are moving, and your lips are really moving. So I've got a few questions
Mr. Cesaro,
for
that's
you.
going to be out of order. There's no
Well,
no
I have a
need
few
for that.
questions for you. Did you say that the insurance company only was limited to up to 2008 to pay claims, or were they not limited for any claims, including Darrow's Ridge, Darrow's Pond, from 2008 onward?
Attorney Sicily, you don't have to respond if you don't want to.
Mr. Formica may correct me if I'm wrong, but my understanding is that the town switched insurance carriers after July of 2008. So AIG is no longer the town's insurance carrier, so therefore this settlement did not affect any claims that would have arisen after July 2008.
And isn't the Darrow's Ridge, not Darrow's, Darrow's Ridge, the Darrow's Pond, aren't those claims subsequent to 2008? In terms of the easements?
The town purchased the property not sure what claims that you mean on the easement. If you could be more specific with regard to the claims.
easements that are being released.
The easements, you mentioned the title insurance property. The easements on a property, when it's conveyed, become somewhat of an underlay or an overlay of what the town or any other purchase that's made with an easement on it. So the easements carry with the property, and now this will get rid of the easements. So that, I don't know about an insurance claim with the easements. That's why I'm trying to understand what really your question is.
Well, I read the lawsuit, it's for $13 million, and the easements and certain restrictions you were trying to put on New England National were part of the claim. And if they're subsequent to 2008, why aren't they taken care of by the insurance, the new insurance company?
I'm not sure we understand the question that you're raising. You do?
The town's general liability policies generally cover tort-type claims, which are negligence and those types of claims. The easement rights are a property right that have nothing to do with the town's general liability policy, so you're comparing apples to oranges.
Okay. So the next question is the indemnification of the insurance company. You just said that the statute of limitations ran out on New England National from pursuing any claims. If that's the case, then why did the case go from $2 million to $13 million, and why did the district court not throw any of these claims out? It's $13 million, so that's what the claims are right now.
I'm not sure, Mr. Cesario, where you're coming up with the $13 million, but the court doesn't just throw claims out instantaneously. There's a long process that goes through. And in fact, the court did throw out about 12 of New England National's claims and was requesting an expedited evidentiary hearing on additional claims that we believe may have been resolved in our favor. But we never got to that point because there would be additional discovery that would have occurred, and then that hearing and trial and the settlement discussions took place before that, and we reached this agreement subject to approval.
And it's true that you participated in the indemnification. You were here for the hearing for the indemnification of the insurance company. And Mr. Block stated that you were supposed to cooperate with New England National. Yet when you said you came to an agreement with the insurance company, you didn't include New England National. And isn't it true that they even tried to stop you from interjecting into that?
Mr. Cesario, we're not here to debate the facts that happened in the past. We're here to discuss a proposed settlement, which is the motion. So I would respectfully say that your question is out of order.
You know,
I understand that.
Sorry,
but
we can't, this is a settlement agreement that's comprehensive, it's taken months. We're not gonna redo this at this point. You're either gonna agree to this settlement, this meeting is gonna agree to this settlement, or it's not.
I'm for the settlement.
But it's not gonna
so-
rewrite this settlement tonight.
I'm
That
for
would
the
be out of
settlement, and
order.
there's criminal charges being filed against Mr. Formica, Sisley, and Block. So I'm for the settlement, but they committed fraud on the taxpayers
But
of East
that's not
Lyme
before-
when it came to the
that's a-
insurance policy.
That's a charge that's completely out of order tonight. Mr. Formica?
Mr. Cesario, with all due respect, you have over the last 2 years sent me malicious and fraudulent and untrue emails. I can tell you that there are no criminal charges being provided against me unless you plan on doing it yourself. But there are no plans to do that. As far as I know, I have not been served.